Hello, everyone. Welcome to the Death Penalty Focus webinar on the constitutional challenge to California's death penalty on the basis of racism. I'm Mary Kate DeLuco, communications consultant here at Death Penalty Focus, and I'm here with Yoko Otani Sperlin, my coworker, who is a finance and business administrator at Death Penalty Focus. We will be taping this webinar, and it will be available on our website in about a week or so. We will send out an email to all of our registrants once it is up and running for you. Welcome. We're glad to have you here. And I'd like to introduce you now to our moderator, Death Penalty Focus board member, Stephen Rohde. Steve.
Hello, everybody. It's a real pleasure to be with you. We're grateful you've joined us today. And I wanted to thank Mary Kate and Yoko for organizing this webinar. On April 9, 5 civil rights and legal groups filed a challenge to California's death penalty in the state Supreme Court. It asserts that the state's death penalty statute is racially discriminatory as applied and is therefore unconstitutional under the equal protection guarantees of the California Constitution. This is a case that is a frontal attack on the death penalty in California. With us today, we have lawyers from 3 of the organizations who filed that legal challenge. I'd like to welcome Morgan Zamora, Prison Advocacy Coordinator at the Ella Baker Center, Avi Frey, Deputy Director of the Criminal Justice Program at the ACLU of Northern California, and Jess Oats, Director of Systemic Litigation at the Office of the State Public Defender. There is a Q&A box available to you on screen. The chat is disabled, and we invite you to post questions throughout the program. Depending on our time, we hope to get to some of those questions. I really thank every one of these panelists for taking the time to be with us, which has to be a very incredibly busy time in their work. I'd like to start with you, Jess, and ask you to briefly describe the key essential legal and constitutional arguments on which you're basing this historic lawsuit.
Great. Thanks, Steve. And thanks, Mary Kate, so much for having us here today. So Steve, as you noted, our petition before the California Supreme Court demonstrates that California's capital punishment scheme is administered in a racially discriminatory manner. So we attached as exhibits a wealth of empirical evidence, both old and new, that demonstrated stark racial disparities in who is sentenced to death, as well as distinct racial disparities at 2 discrete points in the legal process. And those points are prosecutors' decision to seek death and jurors' penalty decisions. The studies were remarkably consistent. We attached 15 statistical studies authored by 13 separate researchers spanning 44 years of data. There were 4 statewide studies, 11 county level studies examining 7 individual jurisdictions. So this is an enormous wealth of data. In the most comprehensive study conducted by Catherine Grosso, she found that statewide, Black defendants are up to 8.7 times more likely to be sentenced to death than all other defendants. Latino defendants are up to 6.2 times more likely to be sentenced to death than all other defendants. And defendants of all races are up to 8.8 times more likely to be condemned when at least one of the victims is white. So the studies uniformly demonstrate that these disparities can't be explained on non-racial ground. So to the legal part. So this disparate impact on members of a suspect classification, race, triggers a strict scrutiny analysis under California's equal protection guarantee. So whereas the US Supreme Court has held that a challenge under the federal equal protection clause requires proof of invidious intent, the California Supreme Court has held that California's equal protection guarantee does not require proof of invidious intent when the application of a statutory scheme disproportionately harms a protected classification. Okay, so the disparities establish that California's death penalty system as applied violates the state equal protection guarantee unless AG Bonta can show that the discriminatory application is necessary to achieving a compelling governmental interest. So he can't do so here. There's no constitutionally compelling state interest in maintaining a racially discriminatory death sentencing scheme. And so these studies demonstrate that California's capital sentencing scheme as applied violates the state equal protection clauses.
Thank you. You've made that very clear, and your case is hereby granted. It is so compelling. Morgan, upon filing this unprecedented lawsuit, your team explained that you are asking the Supreme Court to issue an order halting the pursuit of all death sentences in California. Your announcement states that, quote, this extraordinary order would prohibit the Attorney General and all district attorneys from seeking, obtaining, or executing death sentences. If successful, the order you are requesting would stop the death penalty in its tracks in California forever?
Yes, that's correct, Steve. As Jess mentioned, the suit seeks to invalidate California's capital punishment statute for those reasons, that it's applied in a racially discriminatory manner and violates California's equal protection clauses. And I think that there's a big misconception amongst the public too, that the death penalty is already illegal because there's a moratorium and because the state isn't currently executing people, but people are continuing to be sentenced to death in the state, and they're predominantly people of color. And the only way to move toward real justice for those populations is to get rid of this law and make it so that no one else can be sentenced to this extreme sentence, and to take away the space that this law creates for its biased application.
And if the state promised to do better in the future, that's not enough?
I don't think so. I think you can't make a promise to undo a system and a law within itself that creates space and room for that discrimination and that bias to continually exist.
Avi, who are the petitioners in this case? What stake do they have in each organization and individual that's brought this suit, and that gives them standing to raise these issues?
Sure. Thanks, Steve. And also just want to say thanks for having me and us here to talk about this. We're excited to talk about this case and increase awareness about it. So we're joined by two of our petitioners, not in their individual capacity, but Jess's organization, the Office of the State Public Defender, and Morgan's organization, the Ella Baker Center for Human Rights. Those are two of our petitioners. Latino Justice is another one. And then we have an individual, Ava Patterson, who is a longtime civil rights champion and has worked in this field for decades. Standing, fortunately, in California is incredibly expansive and a generous doctrine. So this was not, among the issues that we needed to spend a lot of time researching, standing was not it. Whether it's organizational standing or taxpayer standing or public interest standing, we felt pretty secure that our bases were covered. And in responses that we've received from the Attorney General so far, there's been no complaint about standing, nor have, I should mention, there have been some district attorneys from counties in which the death penalty is very popular. They have, of their own accord, decided to reach out to the California Supreme Court and file things. They're not raising standing as an issue in this case. So that's not a big concern. Who these organizations are is people who either care deeply about civil rights and or represent people on death row. I mean, OSPD is a state agency. I think we would be kidding ourselves if we said that Jess and her colleagues don't care deeply about civil rights. Their mandate, however, is just to represent people who are condemned and to uphold the law. Then we have organizations that are advocacy organizations and individuals who are advocates like Latino Justice, like Ella Baker Center for Human Rights and Ava Patterson, who are particularly devoted to equality and equality in the criminal law in particular. Ella Baker Center for Human Rights does a huge amount of work with people who are incarcerated, and they are not focused solely on the death penalty, but also other extreme sentences. Latino Justice is a national organization that cares broadly about the rights of Black and Brown people beyond the criminal legal system, but certainly in the death penalty context. So this is, an assembly of individuals and organizations who, for several overlapping reasons, want to see the death penalty in California under the existing statute put away because it has been employed in such a racially discriminatory manner.
No longer are DAs uniformly supporting the death penalty in California. I don't know if you have this at hand, but which DAs have so far weighed in attempting to intervene in the case, Avi? And apparently those so far are opposed to your position?
So San Bernardino and Riverside DAs, which, surprise, surprise, lead the state in capital prosecutions, have raised their hand to say they'd like to be involved. Our position is this is totally inappropriate and wasteful. They're not on the other side of the V, and the Attorney General is the chief law enforcement officer in the state. He can tell them what to do. He represents their interests and the interests of the people. He represents all prosecutorial interests in the state. And so the fact that some particular counties in which the sort of discrimination that we take issue with is wanton in the criminal legal system, including in service of the death penalty, it's very unfortunate, but it's not a surprise to us. This is not, we are also in communication with a significant number of other DAs. Excuse me, I had a noise in the background. Significant number of DAs from other counties. And I can tell you without saying more specifically, their feelings are not shared. The political demographics, the racial demographics vary widely across the state. And in states that have greater concern for race equity in their particular counties, or which support criminal legal reform, the DAs are saying something very different. And some of them we expect to be involved at varying points in the proceedings as friends of the court. And let me stop there. I see Jess wants to chime in.
Yes, Jess, please.
Sorry, Avi, I think you were just about to say this, but we, the Prosecutors Alliance filed an amicus letter supporting our petition and encouraging the court to indeed hear the case as well. So, like Avi said, the San Bernardino and Riverside district attorneys' opinions on the death penalty are certainly not unanimous across the state.
Would you contrast the Prosecutors Alliance with other DA associations? Aren't there several now? Jess?
That's a good question. I'm not an expert on this. Avi may have more information.
I think, to put it bluntly, they take different positions along the political spectrum. All, though, have either included or represented the prosecutors for various counties, past and present. They have all been charged with, prosecuting violations of crime, including capital crime under the existing statute. And so our position, and we can talk more about the amicus who have supported us so far, but our position, which the Prosecutors Alliance was excited to support, was that this is not an issue as exemplified by the submissions of the San Bernardino and Riverside County DAs. that can just be resolved by virtue of prosecutorial discretion. Because what you end up with then is a very piecemeal sort of resolution. And this is really already how the death penalty operates, both within California and nationally, because of the really extreme degree of discretion that prosecutors have, their great power to seek the death penalty. What you end up with is sort of death penalty happy prosecutors pursuing a lot of capital prosecutions, and there are no capital prosecutions in other areas of the state and country. And so the Prosecutors Alliance, as well as many of the other counties in which the DAs don't make use of capital punishment, have weighed in to say, this is a problem, but it's not a problem that we alone are capable of resolving, certainly not systemically.
Very interesting. Let me stay with you, Avi. The arguments have been made, it seems, as I've indicated, are very strong and powerful. I understand that considering all death penalty sentences imposed in the United States in 2023, California was second with 4 death sentences. Florida was first with 5. And is it true that every person sentenced in California were Latino or Black, and that despite the moratorium, 17 people have been sentenced to death since 2019, and 80% of those have been Black or Latino? How do those kinds of facts play into the legal arguments?
Well, first of all, I'm glad you mentioned that. It is true. And the way that they play into the legal argument is, we filed an original writ petition in the California Supreme Court, which is discretionary. We're not entitled to have the case heard on the merits. There's not really much of a legal standard for when the California Supreme Court should or should not, or, there's no must. And so we're trying to appeal to their sense of justice and institutional duty. There is a sense, as Morgan touched on earlier, that capital punishment is not really a problem in California, both because the state is perceived as, fairly blue, and also because of the moratorium in particular. What these sorts of facts show is this is still a very real problem, and that there's a lot of harm going on, which suggests the need for the California Supreme Court to step in and hear this case, because in the absence of the California Supreme Court weighing in, we can only expect that the recent trends will continue apace. The other thing I would say is, there's also a sense that racism, particularly in the criminal legal system, is dwindling, that its impact has been blunted, that since the time of McCleskey in 1987, many people think there's less overt racism. And what these types of facts show is that's absolutely not the case. There's a significant amount of race disparity that represents unconscious biases as well as intentional discrimination. And one of the things that our petition points out is all of the various checkpoints at which those sorts of implicit biases can enter into both the charging and sentencing decisions in capital cases. And so I think the statistics that you mentioned do 2 things. One, they suggest the California Supreme Court really needs to step in and hear this case on the merits. This is an ongoing problem that's very serious. The second is it shows that it's continuing and recent evidence of the exact same trends that the many, many studies that we highlight, it makes the same point. And so I think that's sort of the purpose.
Yes, I think what you're getting at is we have not achieved that colorblind society that Justice Roberts and others imply that we have. And the facts in your case are so startling as a reminder to people that this kind of systemic racism exists. And if even one person were wrongly and discriminatorily executed, we all should take notice of that. And that's what the California Supreme Court should take notice of. Jess, it's not unprecedented for a state Supreme Court to find the death penalty in violation of their own state constitution. Supreme Courts in Washington, Connecticut, and Massachusetts have found their statutes unconstitutional. But are the issues similar in those three cases?
Thanks, Steve. So Washington's case, I think, is the most similar to the claim that we've brought before the California Supreme Court. In Washington, in Gregory, a 2018 case, a criminal defendant invoked a study and argued that Washington's state death penalty was administered in a racially discriminatory manner. And the Washington Supreme Court did ultimately invalidate the state's death penalty under the state constitution based on that single study, finding racial disparities and arbitrariness in the execution of the death penalty.
And do you cite to other states, or are you attempting to strictly keep your arguments based on the California law?
We do cite to other states. We rely, primarily, if not solely, for the sort of basis of the legal argument on California law. But I think it's quite helpful to refer to the mechanisms by which this question has been addressed in other jurisdictions. So yeah, we talk about those cases as well.
Avi, we're in a very interesting political situation in California when it comes to the death penalty because of Governor Gavin Newsom and Attorney General Rob Bonta, who and the Attorney General is a named defendant in this case, because they have publicly and officially acknowledged racial disparities in the death penalty system in California. Bonta, when he was a state legislator, co-authored a bill that would have placed a constitutional amendment on the ballot to repeal the death penalty. That was unsuccessful. And of course, we all know that Governor Newsom has declared a moratorium on the death penalty. And he even filed an amicus brief in a case in which a defendant argued that death sentences violated state law for various reasons. Now, so AG Bonta has been named in your case, and staying with him for a moment, given his position on the death penalty, how has he responded to this lawsuit?
Thanks, Steve. Everything you say is true. To begin, the California Supreme Court asked Bonta to submit a response, which, in the course of an original writ proceeding, is not a necessary step, and it is a hopeful step. It suggests that the points that we've made have at least caught their attention sufficient that they want to hear from the other side. What Bonta said, in effect, was there's there in our pleading. He didn't come out and say, let's wrap this thing up. I'm with them 100%. We can go ahead and cross the statute off the books. What he said was there needs to be, a fuller development of the factual points made and raised in the studies that we cite. And he said this could be accomplished in a handful of ways. And the one that we prefer is the appointment of a special master or referee for the California Supreme Court to retain jurisdiction over the matter, and just to bring in a subject area expert who can examine the methodology and the conclusions of the various authors of the studies, the researchers. It can be subject to some sort of adversarial testing. Our argument is that paper format questions submitted in writing would be completely appropriate and adequate to get to the bottom of this. And the reason we do that, by the way, is just speed. I mean, as you mentioned, this is an ongoing situation. People are being charged with capital offenses in a system that is infused with race bias all the time. And so to slow this down with live testimony, or to kick this down to a superior court for fact-finding by a judge in the first instance, all of those things add months or years, and then presumably add more folks of color both to face capital prosecutions and then eventually to death row. And so, you know, that's the suggestion that we prefer among, but to answer your question directly, Bonta has said, let's move forward with this. Let's address the factual claims so that we can get to the legal issues. He hasn't tipped his hand on the constitutional questions, which is appropriate at this stage. And, you know, it wouldn't be necessary, particularly given he's saying, we don't want to close the door on this question. So that's where he is for now. Whether he has particular, I don't mean to cut you off, Steve, but I was just going to say, we don't know whether he has particular questions about the methodology of any of the researchers. And we have, because he's previously stated, he comes to the same conclusion. We have no reason to doubt that he thinks that the conclusion is suspect. I think that, you know, or I shouldn't speak for myself. Our belief is he's doing his due diligence. This is a sufficiently weighty matter that it requires a certain process. But I'm not sure, as I sit here, that he doubts the veracity of any of the findings that we've put forward.
What strikes me is the approach he's taking seems to sense that this is such a weighty issue that building a record with a special master, testing, examining, expanding on the research would provide greater acceptance and public reliability in an eventual decision that finds the death penalty unconstitutional, and that the public would be more likely to accept such a decision after all of the due diligence and thorough examination you're describing. Does that get at it?
Absolutely. I think that's very well said. I think legitimacy matters. You know, the death penalty is one of these questions that has just about split the population on moral grounds for, 50 years. And so big swings, big changes in policy on issues like this are disruptive, whether they're right on the law or not. And so I agree with you. I think that he has rightly sensed that this needs to be cloaked in, some of the formalisms of judicial process, and that, whether it be a special master or something else, some fact finding or verification, at least of the facts, would insulate any future decision from a sense that this was sort of, strong-armed or over the heads of the people of California.
Morgan, let me turn to you on that question, because I know of the work of the Ella Baker Center, and is there an advocacy approach to these big questions which seeks not to force these decisions down the public's throat, but find common ground and eventually persuade the public to the rightness of the enforcement of these civil rights?
Thanks for that question, Steve. I think that, it's a really difficult issue for some people to wrap their heads around when we're talking about the death penalty and everything that goes with it also. And I think that there's something that Avi actually said, not today, but at some other point in time, that the California Supreme Court and our judicial systems are in place to do what is right and not necessarily what is popular all of the time. And I think that there is so much effort being done in different spaces by different organizations that are advocates for those who have been condemned in the state to change that narrative and to help that understanding. And to, remind people of the humanity of these individuals and the fact that the death penalty in and of itself is not this, it shouldn't be this political issue, and it's more of a public health issue and an issue with, the way in which we treat and respond to people and the empathy that we show people, and, the ways in which Black and Brown and working class populations are more severely impacted by mass incarceration and extreme sentencing of all kinds, including the death penalty. And I think that, there's so much effort being done for increased public education and understanding and trying to bridge that gap, especially with people who are advocates for the death penalty. And I think, this is a situation where it might not necessarily be the most popular decision right now. And it might be, right? It might be that, public opinion is in our favor also, but this is really comes down to an issue with the ways in which our system works and functions, aside from public opinion on the matter itself.
Jess, public opinion is driven by lots of things, but some of it by knowledge and information. And throughout my legal career, I saw public interest litigation as having an educational element to it. It was not just about raising technical legal arguments and convincing 1, 3, 7, or 9 judges of a particular legal position, but that the very case itself, often in trial, but here as well through your evidentiary process, is meant to educate the public. And when well educated, and certainly in light of the stark statistics and facts you're telling us. So do you see litigation of this kind as having a public education component as well?
Well, that's a really interesting question, Steve. I've spent my career representing individual clients, and this is one of my first chances to engage in the kind of litigation, large scale litigation that this coalition is engaging in, and the sort of public education component of this has been an honor to work on this, and has been really sort of enlightening. The Office of the State Public Defender filed a white paper with the legislature a couple years ago, talking about the dysfunction in California's death penalty system. And so, the office does have opportunities to engage in that sort of advocacy, which certainly didn't get as much attention as this lawsuit has. But I really appreciate your perspective on the public education component of this, and it really has been an honor.
That's lovely. Jess, has the question of a special master been ruled on by the court? When do you anticipate that question coming to a head?
That's the $1 million question. The court has no deadline. So the pleadings are in. For now, the court could always request or order us to file more papers before issuing a decision. But your guess is as good as mine right now, Steve.
And in that vein, Jess, is there any concept of a stay of execution? If this court is convinced that you've passed the threshold, you've raised serious questions of racial discrimination embedded throughout the system, one would think a court would say, time out. We're going to look at this, and pending that full and fair review, we should stay all executions in the state of California. Is that in your papers? Is there any intention to seek that kind of relief?
Yeah, we have asked for a stay of executions. Your Exactly right. California right now has a moratorium, but Governor Newsom's, tenure is seemingly coming to a conclusion, and all bets are off at that point. Nothing, I think, can be taken for granted, and I think it's absolutely critical that the court issues a stay. We pause and we look at this really weighty question that affects the entire application of the most serious punishment in the state.
Avi, getting back to some of the support you're getting, you've mentioned sitting DAs. I gather there are former California Supreme Court justices and several California legislators who have weighed in. Tell us and identify some of those parties who have already officially filed amicus briefs in this case.
Well, you've hit the nail on the head. Those are the three. It's prosecutors, a collection of legislators, and members of the judiciary, including a former Supreme Court justice and others. So the thinking behind this is because this is a discretionary matter, filing an original writ, we wanted to answer questions that we presume would be in the back of the court's mind about the propriety of the Supreme Court hearing a case that, as we've said, would effectively end capital punishment in California. And I want to offer one clarification. That is, for practical purposes, that it would likely end the death penalty in California. This is an as-applied legal challenge, which means that there is no stopping the California legislature from, were we to prevail, them trying to pass a different statute which would somehow remove any possibility of race bias going forward. It's not a facial challenge which does away with capital punishment in the state for good. I mention that just as a point of clarification because it is an important piece of the legal argument, although perhaps a bit technical. What we wanted our amici to say is, why now and why the court? So the legislatures basically say, we can't do this. There are a number of things that make it sort of an intractable political issue. And that's not democracy working, that's sort of a failing of democracy. We wanted that point to be very clear, that this wasn't a case in which the justices could sit back and say, well, it's appropriate to punt. The people should decide this issue. We wanted them to be aware of the dysfunction on the issues of the death penalty in particular, so that they would recognize that, that safety net doesn't exist. With regard to the prosecutors, this goes back to a point I made earlier, we wanted them to both own the discretion that exists in prosecutors and the window that there is for bias, including whether it's intentional or implicit, to come in through a number of decision points. And we also wanted them to say, we can't solve this problem on our own. Everyone sort of has control of their own little fief when it comes to county district attorneys. And with regard to the judiciary, we wanted them to sort of, as members of the same group, say, this is institutionally proper. It's proper for you to take the case. It's proper for you to decide the case. And these issues are real and not going anywhere. And so the petition makes the arguments that you would want to be in a petition of this type straightforward legally, why we're entitled to the relief that we're entitled to. But that doesn't answer every question, particularly the questions about how we get in the door on a matter that's purely discretionary, that is a political hot button issue, in which the court could brush it aside without another word, and that would be that. We wanted them to hear from other people that it should weigh very heavily on their conscience, because if they don't answer this question, it will go unresolved, and the harms that we mentioned will continue. And I want to just add one thing to a point that Morgan made, which is so true and crucial in saying that this is a public health issue. And I just want to make sure that folks understand some of what I understand that to mean. And Morgan, if I get this wrong, definitely flesh this out. There is a moratorium. People aren't being executed right now. That doesn't mean there isn't an egregious racial harm in the capital punishment in California right now. Those people who are being charged with capital offenses and their families. Capital punishment is an enormous drain on entire communities. The process of being charged, the amount of grief for not only individuals, but their families and their social networks, the symbolism, the message that it sends, that it's always sent. I mean, this is, to be blunt, a system that has legalized lynching. It comes out of lynching. It went into the criminal legal system because lynching received a bad name in the American South, and it has gone everywhere that people of color went after slavery and Jim Crow. I mean, I have heard this and repeated it myself. If you were to put a transparency of where capital punishment exists over, where slavery existed, plus the Great Migration, where Black people in this country migrated to after they left the American South, that's where capital punishment is. So this is a system of racial subjugation. And you don't have to ultimately execute the individual, as we see not only in California, but everywhere, where it takes 20, 30 years to go through the appellate process. You don't have to actually carry out the execution to inflict that racial harm. It's enormously harmful to condemn people, to put them through that process, and to basically subject individuals to a system that says you're worth less. And so that's why it's a public health issue. It has an enormous financial, emotional, mental health, physical health strain, the stress that this creates, and the insult that it causes. So I just wanted to follow up on Morgan's point because I think it's critical.
That is critical and so important. I understand that amicus briefs have been filed by DAs Pamela Price, George Gascon, and Diana Becton. Our audience is very interested in the DAs in their individual counties. Do you recall the names of the former Supreme Court justices that have weighed in?
Jess, can you help me out? I know it's the former chief, but I'm blanking on her name. I'm not as deeply rooted in California's Supreme Court history as I ought to be.
Justice Moreno filed an amicus letter.
Great. That's really good. So, Morgan, there have been, outside of this case, recent revelations about the exclusion of Black, Jewish, and gay individuals from the juries in Alameda County. How does that fit into this case? Did Jess want to take that by raising your hand?
Sorry, I just wanted to circle back to the last question.
Yes.
Not the Chief Justice, Justices Moreno and Groden. Want to give you a full answer.
Good. We'll correct the record. Morgan, you heard that question about Alameda County.
Yeah, thanks, Steve. And thanks for the clarification too, Jess. But I think it's incredibly relevant what's happening in Alameda County and what's, I don't want to say surfacing because it's something that also surfaced a long time ago and there was no real action taken on it. But I think that it exemplifies some of the issues that we know exist and perpetuate the imbalances and the disparate application that we're fighting against right now and we're trying to call attention to. It's these types of blatantly discriminatory practices that have resulted in so many facing harsher sentences and being condemned in the state on the basis of their identity. And that's something that we know can't continue to go forward in any way in the future. And I think, what has happened in Alameda County and what continues to happen in other counties is not unique. I think if there was an audit of every prosecutorial agency throughout the state going back a few decades, that you would likely find similar sentiments in a lot of those records. And it's a systemic issue and it needs to be dealt with as such. And that's, there needs to be action on a county level in Alameda County and all of the individuals whose cases have been impacted by this bigotry and anti-Blackness and anti-Semitic words, and racism and prejudice of other forms. There needs to be action and accountability to provide relief to the individuals whose cases have been affected by that. And it's just a reminder of why we're doing this and why the Ella Baker Center and every other organization that are petitioners in this litigation, and that the attorneys that are leading this litigation are doing this work and a part of this, because when you aggregate those instances together, it just further justifies our position and that need for statewide action.
Jess, just this month, DPF did a separate webinar focusing entirely on Alameda County. That, by the way, to the audience is available at the DPF website and was extremely illuminating. And if you're curious about what Morgan has just said and the evidence of blatant prosecutorial discrimination in jury selection, please go watch that webinar. Interestingly enough, one of the panelists at that webinar, co-counsel to an individual whose case was the catalyst for discovering the notes of the DA's office indicating systemic exclusion of Black, Jewish, and gay individuals, said that he thinks the main reason the California Supreme Court has ruled against claims of racial bias, he said, in every death penalty case for the last 30 years, is looking back to 1986 and the legacy of the ouster in a recall vote of Chief Justice Rose Bird and Justices Reynoso and Grodin. Now, this is real tough, a tough suggestion, and we have to realize that judges are people too, and in our system, they come up for votes and even recalls. Are you concerned, Jess, that some or all of the 7 members of the current California Supreme Court would reject your case out of a fear they will be recalled or defeated in the next election?
Thanks, Steve. So, I can't get into the justices' heads, but the chief has said that she's concerned about the legitimacy of the court, and that she doesn't want the court to appear political, as sort of contrasted with the U.S. Supreme Court. Bottom line is that we presented a constitutional question, not a political question. And although voters have in the past approved initiatives maintaining California's death penalty, Californians have never passed an initiative endorsing racial bias in the application of the death penalty. I think it's worth noting on your guest's comment that this case presents a very different kind of claim of racial bias than the court has seen before. The court has never decided the questions presented here before, and it's never been presented with the kind of empirical statistical evidence that we have here. So for the very first time, the court has an opportunity to directly head-on address this widely recognized data showing that California's death penalty is administered in a racially discriminatory way. The justices, this is my last thought, justices they're the ultimate arbiters, and really they're the ultimate, they're the final protectors of the California Constitution as a document with independent force, independent of the federal Constitution, independent of other jurisdictions. And this is really their chance to make a statement, to look at this data, to look it in the eyes and to make a statement about the California Constitution and the equal protection guarantees therein.
Avi, let's assume the justices do their job. They make their decision based solely on the facts and the law. given what we already know about the racist application of the death penalty, how do you assess your chances of success?
Well, I'll start by saying, given that this is a pending litigation, 110%. I'm not going to do the other side's work for them. But I'll also say, you'll have to decide for yourself, given what I've just said, if I'm being totally genuine about this, but I am being truthful. I think if we get past this hurdle and they take the case on the merits, then we've gotten past the most difficult stage. I think the facts are inarguable, and I think the law is straightforward. The law does not tolerate this sort of race disparity in the most severe punishment. That's not to say that every legal question is necessarily an easy one. Many haven't been decided. I mean, for example, the extent to which California's Equal Protection Clause differs from the federal Equal Protection Clause, that could be a more developed area of state Supreme Court law. I mean, the extent to which any provisions of California's Constitution and under what circumstances and to what degree they differ from the United States Constitution. Those are all sort of relatively underdeveloped areas. But we're talking about McCleskey versus Kemp, arguably the worst federal constitutional decision of all times. And I say that with full knowledge of, the Dred Scott decision, Korematsu, et cetera. There are some bad ones out there. That's arguably the worst. And so certainly a good place to start in thinking about diverging from the federal Constitution. I think also it's telling, going back to where we started, that what's come up from the AG's initial responses, let's take a closer look at the facts. And I think that there's a signal in there that the legal questions, once the facts are decided, while weighty, are not as difficult. And so I do feel very sanguine about our prospects if the court takes the case on the merits. But as you've just alluded to, even having the facts and the law on your side, sometimes it takes courage for judicial actors to do the right thing, to do what the facts and the law say. And so, getting through that initial gate is a big step.
As we begin to wrap up, you've put your finger on a key question that I wanted to ask Jess. Your lawsuit deliberately is based on the California Constitution and its equal protection provisions. If the court rules in your favor, can a victory be overturned by the U.S. Supreme Court, which is currently in the hands of 6 conservative justices?
No. The most straightforward question I think we could answer today. The state Supreme Court gets the final say about the state constitution, and the U.S. Supreme Court cannot tell California what California's constitution means.
That is very straightforward. I'm asked that by lawyers and laymen alike, and it's important to know that the California Supreme Court will be the last word on this under the California Constitution. Morgan, as we do wrap up and maybe have time for one question or so from the Q&A, what can the people watching this program, DPF's supporters, coalition partners, do to support your case? Is it enough to draw attention to it, write about it, have webinars, or is there more that the public can do?
Thanks, Steve. I think, right now, continuing to call attention to this issue, to make it known to people who might be less versed in this area, to continue to educate themselves and inform others in the community about what is happening in California. I think, we've alluded to it at different points in this conversation, but this is the community that we're talking about, people who are condemned in this state, are really invisibilized a lot. And I think the racism that continues to persist within our legal system is invisibilized a lot. And I think just continuing to call attention to it and, you know, make sure that people are aware of what's happening and knowledgeable about what's going on is one of the most important things, as well as continuing to support local organizations that are doing a lot of this work on the ground and supporting people who are condemned in the state or sentenced to extreme sentences. There are a lot of coalitions and organizations that do really wonderful work, and a lot of them are named as petitioners here or are serving as counsel in this instance, and a lot of them are just in community with us and doing, you know, really powerful work to support people who are on death row and currently incarcerated in the state of California, as well as their family members and loved ones that are supporting them.
Thank you. We at Death Penalty Focus have known all our existence that it is humanizing these cases that's going to make a difference. Today, we've had to talk about statistics and the wider issues, but every single one of these cases involves an individual and their dignity and their right to fairness and to not be the target of discrimination. And I think that's at the heart of your case. We do have time, maybe for, well, maybe. Well, no, look at 12:58. Your call, Mary Kate, whether we take one question or not.
I was just thinking if we could just take one really quickly, because we got two questions about this very issue, is the Racial Justice Act, and both questions asked if the Racial Justice Act can be used in this case, essentially. And I don't know who would like to answer that.
Jess, tell the audience what the Racial Justice Act in California is, and then does it have any application here?
Sure. So the Racial Justice Act in California prohibits the prosecution from seeking or obtaining a conviction or sentence in any part based on race. So you can make a Racial Justice Act claim through a statistical showing at the county level that defendants of another race who were similarly situated were either not prosecuted or were sentenced more leniently. You can also make a showing that one of the actors in the case exhibited racial bias in some way. So there are various elements. So a couple things here. First, the Racial Justice Act makes it incredibly clear what the legislature's intent is in California, and that is to eradicate racial bias in the criminal legal system. But the Racial Justice Act itself, which was really as far as the legislature could have gone in addressing this problem, the Racial Justice Act just doesn't get to the problem that we are seeking to solve. So, at once it makes the intention clear, and on the other hand, Racial Justice Act litigation is piecemeal, it's expensive, it is at the county level, not statewide, it is defendant by defendant, and the California Supreme Court has the opportunity now to address a statewide crisis with reliable, unimpeachable statistical evidence. And that is my take on the application of the Racial Justice Act.
That's very interesting. And as important as it is, your case is at the institutional and systemic level. I just want to thank all three of you. The work you're doing is so important. We're grateful for you coming on today. This has been a really thought-provoking and informative discussion. And not only thanking you for coming on today, but what you do every day when you wake up in the morning and do this work. We're grateful for it, and we thank you very much. Mary Kate?
I would just like to second what you said, Steve. Thank you all very much. We really appreciate it and know how incredibly busy you are. So we really, really thank you.
And for more information on Death Penalty Focus, you can go to our website. A lot of the stories and the information we've been talking about today are there. And this webinar will be recorded and made available. Isn't that right, Mary Kate?
That is true. Give us about a week. It's usually less than that, but we will send out an email to all our registrants letting you know when it is available and up and running.
Thank you very much, everybody.
Bye, everyone.
So much.